Hello, this is Professor Jack Beermann from Boston University School of Law. And the purpose of this video is to give law students some tips on taking law school exams. Now, one note of caution, these are my own tips, my ideas of the best way to take exams and to a certain extent prepare for taking exams. They may not fit the particular kind of exams you're taking. They may be not suited for everyone. But in general, I think that students over the years have found these exam taking tips helpful. And in order to do this properly, I'm going to share a screen which has some slides on this, and I hope you'll follow along and learn something that might be helpful in helping you prepare and taking your exams. So uh, let's get back to the beginning of these. Okay, so um, okay, so here we are. So again, these tips are going to help you both in the actual taking of the exam, and also there's going to be, especially at the end, some tips on how to prepare yourself to get ready for taking your exams. And I have to say that there's no substitute for one thing in law school, and that's spending lots of time studying, whether that's during the semester when you should always be prepared for for your classes, because it's going to be difficult to understand what's going on in class if you haven't read the material and thought about it, whether it's during any reading period you have and spending a lot of time preparing for the exam. And I always encourage students, if you don't understand something, don't leave it hanging. Read a study aid or go to the library maybe and read the entire report of a case if there's an excerpt in your casebook. But whatever you can do to prepare yourself for the exam, I think in my experience, the more time spent with the books, with the cases, and with thinking about it, and with also talking with your classmates about things, the better you'll ultimately do. And of course, the object is to perform up to your potential and not having the mechanics of exam taking get in the way. Okay, so the first thing, of course, is don't panic about exams. They'll all be over soon, and it's only a few hours. And so focusing overly on exams is not healthy. There are many law students who turn out to be great lawyers who, for some reason or other, just don't perform that well on exams. And taking an exam is a pretty special skill. Some of us are really good at it, and some of us are not so great at it. But the exam is only a small slice of your law school experience, so don't panic too much about it. They'll be over, and you'll be able to get back to other more academically interesting pursuits soon. Okay. Now, the first thing is that you have to make sure always that you answer the questions that are asked. And some students don't perform on an exam because they write a general essay on the subject of the course. And that's just not helpful. So if you have a hypothetical and it's asking you to resolve some legal issues, don't bring up legal issues that aren't relevant. And I'll give you an example. For years, I taught contracts. Some contracts questions are asking about whether there's a contract, that whether there was an offer and whether there was an acceptance. But other law school exams are asking about whether there was performance or breach, and other exams might be asking about what the remedies are, assuming there's a breach. And so, for example, there were times when I wrote a question which said, after 15 hours of negotiations, the parties shook hands, signed the contract, and appeared before the cameras and said, "We've just made this important contract, which is going to take our business through for the next 10 years of our business relationship." And then they get in a dispute over performance. And the question is, what are the remedies, or was there a breach or something like that? And in a class of 100 students, I get one or two that would write about offer and acceptance. Now, if the parties appear before the cameras and sign a contract, there's really not an offer and acceptance question being asked there. So make sure when you read the questions that you think about what's actually being asked, and then you write your answers to those questions, not a general essay on everything you learned in your entire contracts class. And sometimes the professor will even ask very specific questions. So at the end of the hypothetical, if the professor says, "What remedy is the plaintiff entitled to if they prove a breach in this situation?" don't write about offer and acceptance. Don't even write about performance, because the professor has said, assuming there's a breach, what are the remedies? Just write about remedies, because most of us won't give you any credit, even if you write the greatest essay ever on offer and acceptance or on whether there was proper performance, if I wasn't asking you about that, I'm not giving you credit for that. I might make me feel better about you and your potential as a lawyer, but it's not going to get you points on the exam. So follow any instructions the professors put in the exam carefully, including things like which side to adopt or whether you're supposed to pretend you're the judge deciding the case. But especially if the professor asks you to resolve particular issues, don't resolve other issues because chances are you're not going to get credit for that. Now, the many law school exams pose hypothetical questions, and some of these hypotheticals can be overly long. I mean, I try to write my exams that where no hypothetical is more than a page or a page and a half. I know some faculty members like to write 15 or 20-page hypothetical questions where you spend half the exam just reading the thing and trying to figure out what's going on. I don't think that's actually what we're testing for in law school, so I don't write them like that. But there's still, you can pack a lot of issues into 3 or 4 paragraphs on a question. So suppose you have a hypothetical in a contracts case, which has questions about whether there was an offer, question about whether there was an acceptance, question about whether there was a breach, and a question about what the remedy would be for the particular breach. So you have to state all those things separately. You have to take each question separately. If you jumble them all together, it's your points are not going to be as effectively expressed. So the way you do it is you take each issue separately. And the first thing you do is say the issue. So the first issue I'm going to deal with is whether there was a valid offer here. And something like that. So the first issue I'm going to deal with is whether a valid offer. Now, the next thing I always recommend doing is state something in the facts that raises the issue. And I don't mean restate the facts. Sometimes students will like to write a paragraph saying this case raises all these different issues because of these facts in general. And that can help. If it helps you get writing, okay, as long as you don't spend too much time on it. But basically, it's really good to bring the facts in a little bit. So you could say something like, the reason there's a question about whether there's an offer here is because the party didn't really specifically say they wanted to make a contract. These facts raise the possibility that they were just sort of speculating about whether they wanted to make an offer, something like that, and state exactly what facts in the hypothetical raise that issue. And that's really important. And especially it's important because if you can't find facts that make that an issue, then chances are it's not really an issue. Okay, so in my hypothetical, if I that I gave earlier, where the parties signed a contract at the end of long negotiations, if you can't come up with a fact which makes it look questionable about whether there was an offer or whether there was an acceptance, then chances are offer and acceptance aren't an issue. So by stating the facts that make it an issue, it keeps you on focus of what the professor is asking about. The next step is to state the legal rule that applies. So let's shift our hypothetical to whether there was an acceptance, and we can think about the old mailbox rule in contracts. So, for example, the mailbox rule says that when the acceptance is deposited in the mail, that's an acceptance immediately upon deposit. So then the question is, under these facts, was there an acceptance by depositing the acceptance in the mailbox? And then, so after you've stated the rule, then you want to apply that rule to the facts. So in this case, the defendant in the case signed the contract and put it in an envelope with postage on it and deposited it in the mailbox, which in most states means that there's an acceptance at that moment, period. And so you've applied the rule to the facts of the particular hypothetical. And again, this helps you stay on focus of what the professor is asking about. And then the next step is to state your conclusion. Therefore, in my opinion, there was a contract made at the moment they deposited it in the mailbox, and any effort after that for the defendant to revoke acceptance or for the plaintiff to revoke the offer was not effective because there was a contract form at the moment it was deposited in the mailbox, even if the mail was never delivered, right? That's the mailbox rule. Or even if a revocation was delivered by some other means before the acceptance was communicated to the defendant. Okay. Now, the next thing to do is to state uncertainties, critiques, whatever. You know, maybe you could say, I'm not really sure about whether there was an acceptance because of this fact, or maybe even to the point was the mailbox rule doesn't seem to make much sense anymore, because you can put something in the mail that might not show up for 4 or 5 days, but in the meanwhile, you could have communicated in an instant through a text message or something else that you were mistaken, you didn't mean to sign that contract, and so therefore there shouldn't be any contract. There's no way that other parties relying on it since they don't even have it yet, that sort of thing. So give any sort of uncertainties or critique you might have about what you said. And then go on to the next issue the same way. So now that we have a completed contract, the next issue is whether there was a breach. And then say, here are the facts which raise the possibility that there was a breach. The plaintiff ordered 100 shares and the defendant only delivered 50. And so now, and then do the exact same thing. What's the legal rule? And then you'd have a rule about substantial performance or something like that. And go through the same way, each issue. By keeping the issues separate this way, your exam will be much more organized, and you'll be able to much more effectively communicate what you know about the question to the professor who's asking it. Now, be sure to be aware of how the issue that you're raising fits into the case. Don't write about an issue that's not raised by the case you're asked to resolve. And I'll give you an example from my checkered past in taking law school exams. When I was a first year in criminal law, there was a bank robbery hypothetical, and 2 of the robbers were killed in the robbery. And I spent about half the answer in my exam talking about unique crimes that those 2 people might have been chargeable with. And the professor wrote in the notes in the margin of my exam, he wrote, they don't usually prosecute the people who died in the robbery. And so clearly he wasn't asking about what those people had done. So that's really important to make sure that what you're raising is something that's relevant to the question you're being asked. Don't answer a question that no sane professor or even insane professor, if the professor is more like me, would actually raise. Okay. Another thing is, don't spend time restating the question in detail. If you write a page or 2 pages just saying, here's the question, basically what you've done is you've wasted a lot of time. And so, unless you're giving insight into the issues while you're doing this, it's not really a good idea to just restate the whole question. The second thing is, don't ever try to squeeze everything you learned into the exam, because chances are that the exam is only asking you for 10 or 15 or 20% of the issues that you actually covered in a course. There's no way you could, in a 3 or 4 hour exam, you could ask people to explain everything they learned. So the professor is being selective, figuring that by randomly choosing a certain number of issues, it'll show how well you understood the entire course. If you try to squeeze everything you learned to the exam, you're going to be spending a substantial amount of your time on issues that weren't being asked. So don't do it. Don't try to squeeze everything you learned. And always, always, always connect your discussion to the question being asked, so that you don't go off on some abstract tangent that's not really relevant to the case. So if you're asked a question about reliance damages and you start opining on issues about the possible other damages the person would have gotten, let's say, for example, restitution damages or expectation damages, then you're going to be going way off the track of the question, and it's not going to help, and it's too abstract. Stick to the question being asked and keep your discussion in line with that question. Okay, don't be afraid to say, this may be a weak argument, but, and very often you'll see that you might think, well, would this really be an argument? I'm not sure. If you are making a relatively weak argument and you don't say, I realize this is a weak argument, the professor may wonder, well, does this person really think this is a good argument? But if you say, this may be a weak argument, but, and then explain why and what you want to argue, you may actually get extra points for sort of being creative and trying to push the envelope a little bit, and in a way where you're conscious of the fact that it's not really that strong of an argument. Now, another thing is you may have uncertainties in the question. So you may say, I don't know, and here's why I don't know. And that's sort of related to the facts don't tell us whether. And when I was in law school, I remember I got asked a very difficult question about how to file a security agreement in a secure transactions question for a mobile oil rig that just happened to right now be in the Gulf of Mexico, but could it be almost anywhere in the United States waters? And the question was, where do you file the papers to get your security interest in that? And I said, I don't really know, and here's why I don't know. And I explained uh, what the statute involved, the secure, the Article 9 of the Commercial Code, what it said about where you're supposed to file. And I said, but it doesn't tell you where to file for this. And that ended up being a pretty good exam. In fact, in that exam, the professor wrote in the margin, I don't know either. And usually professors don't know the answer to the questions they're asking. They were trying to ask a question that's hard. That's called a law school hypothetical for a reason, because there's no established answer to it. And sometimes you have to assume facts. Now, don't go around assuming every fact in the world that makes the question easier. But there may be situations in which you have to assume, I'm not really sure if it doesn't really say that the defendant signed the paper, but I think they did, something like that. Assume something that seems to be important to figure out the answer to the questions. And no, you don't want to actually say this is the dumbest question I ever read, even though a couple times I thought this was a really dumb question. I don't think you really want to say that to your professor, that they wrote a dumb question. Anyway, okay. Now, what if we're on a short answer? So a lot of professors like to ask maybe one or two hypotheticals and then maybe 3 or 4 short answer questions. Some professors ask all short answer questions. So again, make sure you're answering the question that's being asked. Don't go off on some tangent of something that's not really being asked. If you can fit it into the time or the word limit, if there is one, give an example or two. That always helps to show concretely that you understand what's going on. And then you also might want to think about situations that may be a little bit different, a little bit of variation, and you might have a completely different answer, you might say. And that also helps show that you really understand what you're saying, because very often it's hard for a professor to understand, to know whether you really understand what you're saying, or if you're just parroting some language from a case or from some study aid or something, or some lecture that you heard, something like that. So that's a good idea. Now, on multiple choice questions, I always suggest reading the answers first, because when you read the 4 answers, usually there's only a couple of them that would be the answer to any conceivable question that anyone would be asking. But then, of course, make sure you understand the precise question that's being asked. That is, I think too often there's a temptation to zip through multiple choice questions, and people will miss an important word or two, and then they'll give the wrong answer. So make sure you really focus on the question that's being asked. And don't spend too much time. If you get stuck on one, go on to another question and then go back. Some faculty members will give multiple choice, numerous multiple choice questions, 50 or something, that you're supposed to do in an hour or something like that, which, do the math, it only leaves you a little more than a minute to do each one. And so in that kind of case, don't spend a lot of time. And if you have to, assuming the professor doesn't penalize for wrong answers, then, put in a guess. And then flag it so that if you have time at the end of the exam, you can go back and reconsider it. Now, here's some tips about studying. First of all, there's no substitute for spending a lot of time studying. One of my colleagues used to say, you have to put the seat of the pants to the seat of the chair and spend your time. And it can be painful and it can be difficult. So I always recommend every 45 minutes or an hour or so, getting up, stretching, getting a drink of water, something like that. But you really need to spend the time. And that means going over the cases in detail, going over your notes in detail. Now, I always suggest rereading your class notes, and even maybe trying to create a shorter version of your class notes, because usually with the class notes, what you decide to write down reflects what the teacher thought was important, because different people think different things are important in the same course. And different teachers have different ideas of what's important. Some teachers really want you to learn the legal rules. Other teachers really want you to learn the methodology. Others it's a mixture. And so what you tend to write down in class will more likely reflect what the teacher thought was important. And by the way, I always suggest that when you're taking notes, don't try to just transcribe everything that's going on in the class. Sit back, listen, and then write down the important things, the things that you think are important. Because that'll help you in studying ultimately to focus on what's important. Now, don't be afraid to consult study aids like the Emmanuel Outlines or the Inside series that are published by my publisher, Wolters Kluwer. they're often pretty good. Most of them are written by faculty members at good law schools. You know, as long as you don't rely on them too much for your day-to-day preparation, which you really need to do, you need to read the cases that the professor or whatever materials that the professor assigned in advance so you can really understand what's going on in the classroom. But I think that these things can be very helpful. You might want to look at who wrote them, and if it's a professor at a good law school, that may make you more confident. But my experience is that almost all of these things are very good, and especially I like the Emmanuel outlines in administrative law and the Inside Administrative Law book from Walters Kluwer. I just happen to think those are particularly good examples of these. Okay, now another study tip is to look at old exams from your professor, maybe take one and talk it over with classmates, friends and classmates, your study group if you have one, that sort of thing. Look for if the professor also has model answers to exams. Take a look, do it first, then read the model answer. Try to figure out if you're on track, and if you're not on track, talk to your classmates and work to get yourself on track with these sample questions or old exams. And then sample question also in the study aid, for example, like the Emmanuel outline administrative law that I happen to like so much. If you can find sample exam questions in those, then they can also be helpful to study from. If not writing answers, then maybe discussing them with classmates in your study group. Now, caution, you want to take a look at your own professor's exams if if any are published, because your own professor may write way different exams than what someone who wrote one of these study aids did. And also their model answers may be way different from what the study aids do, because the model answers in the study aids are most likely written by either the professor that wrote the book, or in some cases by students who took classes from that professor. Okay, and then again, with multiple choice questions, it's a good idea to practice taking multiple choice questions. So look for those. Look for those on the course website or in a study aid. And the main thing, the final thing I want to say is that if you're, when you're studying for an exam and when you're writing an exam, think about writing the exam as if you're trying to explain the issue to someone who's smart enough to know law generally, but not completely immersed in everything you're saying. You need to state all of the steps. Too often, students will write on an exam, here's the issue, here's the conclusion, and they don't give you the steps in between. And just like in math classes in high school, when the teacher would always say, show your work, in law school exams, it's really, really important to show your work. And what that means is show all the steps in your reasoning. Don't leave any out. Go nice and slow, plodding along, and explain how you got from question to answer. If all you do is state conclusions, it doesn't give the professor enough of an idea that you really understand what you're saying, and it doesn't get you all the points you can get from the professor giving that exam. So I'm going to stop sharing this screen now. I hope this was helpful, and in preparing for and taking your exams. And again, the main thing is that you need to spend a lot of time and a lot of effort in preparing for exams. Calm yourself down if you're nervous about it. Take a deep breath, take a break, watch an old episode of Gilligan's Island to get yourself back in the mood to sit down and do it. But I guarantee you that the more time and effort you put into it, the more you'll get out of it, both in terms of your performance on exams and also in your general knowledge as a lawyer. Because what you want to do is you want to know enough about the subjects you took so that when one of your colleagues at the firm, or if you're clerking for a judge, either the judge or one of the other law clerks, or someone you're working for or with comes in and asks you a question, at least you have a rough idea based on your experience in law school or in whatever other endeavor you engaged in that helped prepare you for your job, that you can give an intelligent answer or at least point the person in the right way. Okay, well, I hope you enjoyed this video. And if not, well, you only wasted about 20 minutes. But if so, hopefully it'll help you. And there may be more videos on law school issues coming from this same source. But in the meanwhile, take care and good luck on all your law school exams.